For this development, let's turn to a lawyer and public affairs analyst, Tunji Abdulhammed. It's a pleasure to have you on the news tonight. I'm going to read exactly what I wrote so I don't miss it. The DSS took him to court, but he is in the custody of the ICPC. The court is being urged to order the production of the defendant, regardless of which agency has custody over him. Help us explain this. How common is this scenario in the legal space, and how might that impact the case going forward?
I think what actually happened was that the matter was fixed for because of the application filed by the counsel to El-Rufai. Madam El-Rufai, you recall that he filed a motion asking the court to quash the charge. Probably that is why a date was given to them, because he has not been arraigned. So if you have not been arraigned, the court will not assume jurisdiction over you. In arraignment here means that that's a situation whereby it will be before the court and they will ask him, they will read all the charges to him and ask him whether to plead whether guilty or not guilty. It is when that happens that the court will now assume jurisdiction over him. So until that happens, nothing can be done before the court, and that's what the court is talking about. That's what the court is saying, that it's premature. Having not been arraigned before the court has no power over him yet until that takes place. So the issue that we're having is because there are multiple agencies investigating Malam El-Rufai, so, and it's currently before the ICPC. So ICPC is holding him in custody, and because it's in ICPC, the DSS has no power over control over the ICPC. But like you said, the ICPC, if once the time comes to arraign him, and there's not in any custody, it can be asked to be produced before the court. But as it is now, I think they are not ready to arraign him before the court, and until that arraignment takes place, no application, whether for bail, whether for whatever, cannot be entertained. And so the application has not been considered, talk less of being denied. So he has not been even entertained by the court. The court only said that, look,
I might sound like I don't understand, because for that to happen, he has to appear in court. One of the requests is for the court to order his production. Can't the court do that, considering that both agencies don't have authority over them, either of them don't have authority over each other?
That can be done if proper application is made. But if there's a genuine excuse for his absence, the court will also consider that. You know, it's not one-way traffic thing. If there's a genuine application for his production, if it's before the DSS now, it's in their custody, and they fail to bring it, yeah, that would be easy for the court to do. But it's with a different agency. And if you ask for him to be produced now, the ICPC may say, we are still investigating him. And if it's arranged based on the case filed by the DSS, the court might say after that it should be detained in the custody of DSS. So how will the ICPC continue their own investigation? That is the problem that will emerge. So but the problem we are having is that, look, we have agencies of similar responsibility doing the same thing in a way, as far as I'm concerned, to an extent. These are cases that some of them can even be done by the they will tell you they are still doing their investigation. I want to say they can be handled by the Attorney General Office, but investigation is by the security agency. So they will tell you they are still doing their investigation. But if you are doing an investigation, you have not concluded it, why are you holding him in custody? But that is our system in Nigeria today. They will hold you in custody, they will put you in custody, and then they will be looking for evidence against you. That is why it's looking the way it's looking. The court has not done anything contrary to the law. The court has said the right thing. Look, once a defendant or person accused of an offense or alleged of an offense has not been arraigned before the court has no jurisdiction over that person. You must be asked. The charge must be read before to that person. He must either say that I plead guilty or I plead not guilty. So once that happens, then you can bring whatever application you want to bring before the court. As it is now, it is premature for the court to even entertain any application, whether the bail application or for the application to quash. The charge has not been taken properly before the court.
Thank you very much, Tunji, for speaking with us.